Wood, on page 17.
What happens when someone gets 6 criminal charges in just a matter of months? Today we're diving into one of the most shocking cases of repeated violations we've ever seen. We got assault charges, protective order violations, and a defendant who literally jumped on a car hood with a rock. This is the case of Mr. Woods, a man facing multiple assault charges, including assault of a pregnant person, and a judge who's had enough. You're about to witness what happens when the justice system reaches its breaking point. The GPS ankle monitor, the 1,000-foot radius, and a judge who says he'll do everything in his power to protect the citizens of Harris County. Buckle up, because this courtroom showdown is about to get intense.
Again, and again, and again, and again, Mr. Woods. Eight 14-23, assault of a family member. 6-9-24, violation of protective order, assault bodily injury. Another assault bodily injury. February of 24, assault of a pregnant person, for which you're on deferred now, and now you've picked up another. You now stand charged with criminal mischief. You are facing up to 6 months in jail and or a $2,000 fine. So 1, 2, 3, 4, 5, 6 cases, all in a matter of months.
Hold up. Let's break this down, because what we just heard is staggering. 6 criminal cases in just a few months. We're talking assault of a family member, violation of protective order, multiple assault charges causing bodily injury, and the most serious, assault of a pregnant person for which he's currently on deferred adjudication. For those who don't know, deferred adjudication means the court gave him a second chance to avoid conviction if he stayed out of trouble. Spoiler alert, he didn't. Now he's facing criminal mischief charges with up to 6 months in jail and a $2,000 fine. This isn't just a pattern of behavior. This is a dangerous escalation that the court can't ignore. The question is, how many chances does someone get before the system says enough is enough?
We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. Mr. Woods.
Yes, Judge. The defendant was traveling with the complainant to go see the defendant's child with his child's mother. The defendant continued attempting to be sexual with his child's mother, and the complainant engaged in a verbal altercation with the defendant. Upon arriving home, the defendant exited the vehicle and the complainant drove to a store close to her home. The defendant took the complainant's iPad and walked and followed the complainant to the Kroger. The defendant then jumped on the complainant's hood as she was driving and struck her window multiple times with a rock, causing damage to her vehicle. Estimated damage was $300.
Who is the complaining witness in this case?
The complaining witness in this case is a Jacqueline Perry, who is the same complainant in the assault of a pregnant person.
Tell me he's not supposed to have contact with this complaining witness? Guys,
Morgan.
Mr. Woods is on deferred for assault of a pregnant person.
Wait a minute. Did you catch that? The victim in this case is the same person he allegedly assaulted while she was pregnant. This changes everything. We're not talking about random incidents with different people. This is targeted, repeated violence against the same victim. He stole her iPad, followed her to Kroger, jumped on her car hood while she was driving, and attacked her window with a rock. This isn't just criminal mischief. This is stalking, harassment, and a clear pattern of domestic violence. The fact that he's already on deferred adjudication for assaulting the same woman while pregnant and still continue this behavior shows a complete disregard for the law and her safety. How is he even out on the streets right now?
Yes, Judge, I'm emailing the felony prosecutor right now.
Was he, as a condition of that, not to?
No threatening, harassing, or abusive contact with the complainant in that case.
Mr. Woods, I'm going to find that there's probable cause to go forward with your case. I'm now sending you for a drug test. I want to know what, if anything, is in your system. If you fail to go take the test, if you fail to come back, I'm going to revoke your bond and I'm going to make it so high. On one ankle, I'm going to put a GPS monitor because I'm ordering you not to have contact with this person, and you've shown repeatedly that you are incapable of following bond conditions. And I'm going to put a 1,000-foot radius that you're not to have any contact with this person. You're not to have any weapons. You're not to consume alcohol or illegal drugs. And I'm going to test you repeatedly so I know that you're not using, but I'm sending you now for a drug test. Like I said, you failed the test, and if you fail to come back, things will not go well. Do you understand, Mr. Woods? Yes or no?
Yes, sir.
This is what accountability looks like. The judge just laid down the law, and I'm here for it. GPS ankle monitor with a 1,000-foot exclusion zone. That means if Mr. Woods even thinks about going near this victim, law enforcement will know immediately. No weapons, no alcohol, no drugs, and repeated testing to ensure compliance. The judge literally said, "You've shown repeatedly that you're incapable of following bond conditions." That's judicial speak for you've lost all credibility. The immediate drug test isn't just routine. It's the judge saying, "I want to know what's influencing your behavior right now." This isn't just about protecting one victim. This judge made it clear he'll do everything in his power to protect every person in Harris County. That's a judge who's seen enough.
Take a seat for me.
Presumptive positive for alcohol usage.
Okay. I'm Mr. No, nothing else, just that's it?
Yes, sir.
Okay, Mr. Woods, I'm telling you now, no alcohol, no dope. I'm gonna test you like crazy. If I find that you're using, it's not good. Do you understand me?
Yes, sir.
I'm putting a monitor on your ankle. I don't want you to go within 1,000 feet of where she lives, where she works, where she breathes, hangs out. I will do everything in my power to protect every person of Harris County. Do you understand?
Yes, sir.
You are on felony probation. It's very possible they now issue a warrant for your arrest because of, number one, picking up this case. Number two, the complaining witness. We are going to reset your case to give you time to hire a lawyer. Probably behoove you to talk to someone quick. Mr. Woods, in this case, a protective order has been issued. I would get to know it because if you violate the protective order, the state can and will file a violation of a protective order against you. And then things will really go sideways quick. So take heed of that protective order. There is an exclusion addressed on J Street that you're not to go to. Don't do it. We have a monitor on you so we know exactly where you will be going and where you're not to go. You understand? Okay, sir. I'll have you sign a wreath of Victoria. We'll have you get with Felicia for your bond conditions, then you're free to go.
Let's recap this absolutely wild case. Mr. Woods faced 6 criminal charges, including assault of a pregnant person, multiple protective order violations, and criminal mischief, all within a matter of months against the same victim. Despite being on deferred adjudication with clear no-contact orders, he allegedly stole her iPad, followed her to a store, jumped on her moving vehicle, and attacked her with a rock, causing $300 in damage. The judge's response? Zero tolerance. GPS ankle monitoring with a 1,000-foot exclusion zone, mandatory drug testing, no weapons, no alcohol, and a stern warning that violating these conditions will result in immediate consequences. He's also facing potential felony probation violations that could land him behind bars. This case shows what happens when the justice system has to protect victims from repeat offenders who refuse to follow court orders. If this case shocked you as much as it shocked us, make sure to smash that like button. Share your thoughts in the comment below. Do you think the judge went far enough? And don't forget to subscribe and hit the notification bell for more jaw-dropping courtroom breakdowns. We upload new cases every week that you won't want to miss. What case should we cover next? Let us know below.